Justices of the Appellate Division, 4th Department, hear ye, hear ye, hear ye. All persons having business before this court will draw near, give their attendance, and they shall be heard.
Good morning, please be seated. First case for oral argument this morning is 212 People versus Megan Zona.
Morning, Your Honors. David Abatoy from Megan Zona. My opponent has conceded our main argument here and leaving open, I think, perhaps only a dispute about the remedy that this court should grant. Unless there's any questions about the rest of the substance of my brief, I intend
You
to...
can go right to the remedy.
Thank you, Judge. That's my intention. I know there's some perhaps divergent case law from this court as to how to treat this subject matter. And, I don't know whether this is the appropriate case to try to resolve that, but I will urge this position on the court. I think this is the ideal case to apply the double jeopardy principle, if only because of Ms. Zona's repeated attempts in the trial court to get the court and the prosecutor to only try her for the thing that she was indicted for.
But that sort of touches on preservation, Mr. Abatoy. Why does that matter vis-a-vis the remedy and the impact of, as you say, the possible application of double jeopardy? I'm having trouble with connecting those two dots.
I realize that it also demonstrates her preservation of the issue, but I think when this court examines the double jeopardy question, really what the court is looking at is whether there is perhaps some kind of implicit waiver of double jeopardy that you might have in a case where there's just a regular trial error that might result in, for example, a mistrial, like an evidentiary concern or something like that. That's when she makes these objections in the lower court, she's not really making an evidentiary objection. She's invoking her right to only be tried for what she's indicted for. And what we have here today is perhaps a situation where the only way she can obtain her right to only be tried for what she's indicted for is to perhaps, if the court were to go this way, waive her right to double jeopardy. And
I'm sorry to interrupt you
No,
again. It's an interesting issue, at least for me.
Sure.
But with respect to this record, I'm not sure that we have enough on this record to get to the double jeopardy issue. If we were to do that, that wouldn't preclude you from raising it. If we were to direct representment or a new trial, you could still have that opportunity to raise it below, correct?
if the court were to, yes, I suppose, make that clear, yes, we could.
We have to do some remedy because there's conceded error, and
Right.
one could argue it might be a valid conceded error. But they would still be, so to speak, alive if we were to permit representation and or a new trial.
Possibly, although the court may end up facing the issue at some later point as well. I guess I'll say this, Judge. I think implicit in my opponent's concession is the possibility that my client was actually acquitted of the thing that she was charged with below. And since...
That's where I have an issue.
Okay.
And that's where I looked back at McNabb,
Yes.
which seems to be the genesis of this in our court.
Right.
McNabb, the acquittal was for what I would call apples to apples.
Okay.
So that McNabb got convicted on X offense, and it was the exact same charged offense in McNabb where the person was acquitted.
Okay.
Here we don't have that. We have a single offense crime versus a course of conduct crime. So we don't have, using my casual phrasing, apples to apples. So that's why this might be different from McNabb vis-a-vis the remedy.
I get that. I get that distinction, Judge. I think that's maybe a little bit of friction along the way towards the result I'm advocating for. But I think actually that the thing that ties these acts all together, if you're looking at McNabb and you're trying to draw apples to apples comparison for McNabb, the thing that draws this all together is really the time period, because the allegations of manual touching or oral sex, etc., are really just defined as sexual contact, which is defined as, quote, any touching, etc., of a sexual nature, and that they all clearly were meant to be demonstrated to have occurred within this single time period. And so she was, in fact, only indicted for the one of them, but over that same time period, the prosecutor proves multiple acts. I think the court essentially deals with the same thing in comfort. And I'd also ask the court, perhaps as a good counterpoint to judge what you've expressed with respect to comfort, to take a look at another case that I found last night, is not cited in my brief, People versus Burns, 303 AD 2nd 1032. That's a case where a
Give me that
person,
one more time, please.
yes, 303 AD 2nd 1032. That's a case where a
Have you
person,
given that to opposing counsel?
I've only found it last night, Judge, so no, I have not mentioned this case yet. It's a case where a person was prosecuted for illegally contacting his girlfriend, once by letter, and he was charged with harassment for that, and then once by phone, and he was charged with violating a court order for that. And the judge doesn't make clear in the jury charge, or perhaps makes it possible that he could be convicted of violating a court order for the letter or the phone call, or the letter or the phone call. And this court said that that was a McNabb issue. And I think that perhaps goes to the apples to apples type issue that is.
Which, in that instance, in the Burns case, which preceded the other, the phone call or the letter?
If I recall, and I think this makes my point even more clear on the time period issue that I was discussing, they were both alleged to have occurred on the same date.
Well, the order of protection was in effect when, before.
Right.
What precipitated the order of protection?
I either don't remember or the case didn't explain it, but it was clear that an order of protection was in place and that the allegation was that the phone call was a violation of the order of protection, and by limiting the bill of particulars, the letter was not, for whatever reason, if it was a mistake or what have you. But it was clear that the same time period was at play, but only one of the acts violated the court order, but the judge's charge left it open that the letter could be a violation of the court order, which it, based on the charging documents, it could not have been.
Mr. Ebener, I also looked at a case that you cited in your brief a couple of times, the Court of Appeals case in Kendall, Keindl.
Yes.
There, the court remitted for representment.
Right.
So that seems to be, in this area, a leading case. And there, the Court of Appeals says representment, so I'm having difficulty getting to the point of dismissal on this record. Can you address Kendall for me and whether or not that applies here?
Right. I think this court has addressed Keindl several times afterwards and has come to these divergent applications of it. So I know there are instances like Keindl where they have said that representment was allowed, but I think that, as I said, on these particular facts here, where Ms. Zona is repeatedly insisting on it, on her on her right to only be tried with respect to this particular accusation, that she shouldn't be considered to have then waived her protections. Essentially.
Yeah, we'll look at that really carefully. Obviously, we've all zoned in on what the issue is.
Thank you, Judge. Thank you very much.
I'm sure you, Mr. McCarthy, have now zoned in on where our issue is.
I think so.
And if you were to tell the court you weren't going to retry her, that would make things simpler. But I'm not looking for you to make things simpler.
Well, I'll do the best I can, and the best I can is I'm, in speaking with the trial prosecutor, I'm not entirely sure that can happen anyway.
I know you can't go there, it's just kidding.
Yeah.
Forgive me, Mr. McCarthy. but-
You guys read the transcript, and I imagine you got a flavor for how this trial went, and the reluctance that the child victim had to testify at this trial.
It's such an unusual case because
Yes.
here, the problem fully doesn't get disclosed until after the 330 motion's made, and the grand jury instructions to law limiting to a particular event, particular act, is finally made known to everybody. So that is a complicating factor that I haven't seen in another case. Have you found anything along those lines?
Not really, no. But I think you're sort of touching on the preservation issue. This is not one of those cases, though, where the defendant did nothing. And unfortunately, because I feel that the defendant did enough, I had no choice but to concede. I mean, the defendant asked for it to bill particulars. They raised it in the trial order dismissal. The court had repeatedly sort of denied that request. I don't know how many more times they needed to make it. Maybe they should have objected to the jury instructions, but.
Let me take you to the representment request that you put as a remedy
Yes.
in your brief. There's a part of me that seems to say that's rewarding bad behavior. That is, everybody in the courtroom but defense counsel and defendant knew, or at least should have known, what transpired in the grand jury room. The court looked at the minutes and denied the motion to dismiss early on. The prosecutor, at least the office, is in the room. I mean, if we were to allow a grant request for representment, how would that work? Would you represent just on that single act? Or would you represent on more than that? And how would you avoid double jeopardy? A lot of questions.
I think in terms of avoiding double jeopardy, everything that went to the courts could never be represented because
Say that again?
everything relating to the course, the behavior that the prosecutor attributed to the course of sexual conduct couldn't be represented, and it would only be the single act of vaginal touching.
So you would represent, just theoretically tracing this out, you would only be able to represent the single act that was charged to the initial grand jury.
Correct.
If that was all allowed, why not just go to a new trial rather than representment?
Because I believe the way that, when I look at what has occurred when duplicity has occurred, it's always resulted in a dismissal. And I didn't find cases in which there was a reversal. But I could,
Dismissal with prejudice or dismissal?
dismissal with leave to represent.
But why not do, instead of leave to represent, why not do a new trial since the error arguably happened at trial? I'm really struggling with this, as you can see.
I know, and I think part of the problem is because you cited to McNabb, there was a line of cases in this court that sort of preceded the Court of Appeals decisions in Alonzo and Allen, I believe, where, I think it was Allen, where they said the testimonial duplicity had to be preserved, and that overruled this court's holdings that it didn't. And after Allen, you saw the shift, or at least I saw the shift between the dismissal with prejudice that occurred before in cases like McNabb and Comfort, and then the dismissals with leave to represent that occurred after, which included the Bake case that I cited. So I wish I had an answer, but I really don't.
As I said to opposing counsel, we've got to look at this and drill down.
Did I answer your question, though? To the
think
best
so.
I could?
And to the best I can understand it. So it's a difficult issue, and thank you.
Appreciate it.
Thank you.
No other questions? Thank you.
213, People versus Marco Almonte. Just have to wait 1 minute, okay. Morning, go ahead.
Good morning, Your Honors, and may it please the court, Peter Banishak for Mr. Almonte. I'd like to address points 1, 4, and 5 this morning, unless the court has questions about any of the other points in the brief. And starting with point 1, the lower court here erred in refusing to charge second-degree unlawful imprisonment as a lesser-included offense of second-degree kidnapping. There was a reasonable view of the evidence that Mr. Almonte restrained but did not abduct the complainant. Whereas restraint only requires the defendant to restrict a person's movements in a manner that substantially interferes with their liberty, abduction requires the additional intent to prevent the complainant's liberation. And here, the complainant testified that for about a 1-minute period of time during a domestic violence incident, Mr. Almonte pointed a gun to her head after threatening to kill both her and herself, and that she did not feel free to leave during this period of time. While she additionally said that she did not feel free to leave after this occurred, she did not specify what specific actions, if any, Mr. Almonte took in order to restrain her or to prevent her liberation after that.
Counselor, excuse me, concerning that liberation, not only did Mr. Almonte display the deadly weapon in this case, he ran upstairs to grab the gun. She was aware of the fact that he had a gun upstairs. This is after an incident, other incidents where he physically abused the victim. So he ran upstairs, grabbed the gun, he came back down. her 13-year-old son was present at the house as well. I think his comments that he would made appeared to also involve the child as well, that he was going to kill not only the victim, but her son and himself. Kept the victim trapped inside the house until the next following day, continued to follow her around the house with the gun, standing guard at the door, and separate apart more as far as the gun itself. He didn't leave her alone. He was following her around with the gun. He had the gun. So, how could she liberate herself with that, and the fact that her son was still in the house as well?
Judge, I have to respect, my position is that view of the evidence is not in the light most favorable to Mr. Almonte. And I think that the people certainly indicate all those things, but in looking at the transcript pages cited by the people's brief, I don't think at any point in time the complainant specifically says that he stood guard at the front door or that he followed her around with the gun. Her testimony instead appears to be somewhat...
She made it clear that she knew he had the gun and that he was near the front door and roaming around the front door.
Well, she said that he was in that area, but she wasn't sure what room he was in. But I think if we're viewing the evidence in the light most favorable to Mr. Almonte, it's not clear that he's taking... he's engaging in behavior to specifically prevent her liberation. I think it's possible it would have been possible for the jury to infer that complainant was simply afraid of what could happen because of the general nature of this relationship, rather than based on, and Mr. Almonte's heightened anger, rather than based on specific actions that he was taking after that moment when he pointed the gun at her.
Well, wouldn't it be reasonable for the victim to infer this potential instance where more violence would be bestowed upon herself and her son, considering the fact that on the very first one of the very first days that they started their relationship, he punched her in the face, knocking her tooth out, and later on choked her to a point where she became unconscious. She fell to the ground. She urinated on herself, which is clear evidence of strangulation in violation of 121.11 of the Penal Code, along with other various threatening instances. If they didn't have if they didn't have sex, he would beat her. Altogether, wouldn't the jury be able to infer the fact that she obviously was fearful of this and had no way out of this situation with him walking around with a gun?
Your Honor, I think that's fair. That's one possible view of the evidence, and I think that establishes that perhaps there's legally sufficient evidence in this case, maybe. But if the evidence is viewed in the light most favorable to Mr. Almonte, then I think those things are all true. But it doesn't mean that on that July 3rd date that he was continuing to engage in behavior with the intent to prevent her liberation. Instead, this was an argument, and during that moment when he pointed the gun to her head and menaced her, there was restraint, but there wasn't a prolonged kidnapping sort of a situation as there was.
I think we have that argument. I'll look at that very carefully.
Thank you, Judge. Moving to point 4, it's our position that the lower court erred in finding that Mr. Almonte utilized deadly physical force for purposes of second-degree strangulation and the third-degree assault counts. While,
as I pointed out, the one incident, he strangled her to a point where she became unconscious. She fell to the ground, and she urinated on herself. Those are all factors or clear evidence of strangulation. Strangulation, and especially in a domestic violence situation, is one of the major causes of death of a victim.
It is, Judge, and we acknowledge that the Third Department has said that strangulation constitutes deadly physical force. I make 2 points in our brief that I would ask the court to consider. One is that the statute defines strangulation as essentially criminal obstruction of breathing that causes loss of consciousness, stupor, or other physical injury or impairment. And so
Which one do you say didn't happen here?
no, I think stupor did happen, and I'm not saying that any of these things didn't happen or that
She urinated on herself. That's loss of
That-
consciousness.
that was certainly the testimony, Judge. But I think the question is,
Didn't he tell her to didn't he tell her to get up and go and clean yourself up?
that was her testimony. But I think for the justification instruction, Judge, again, we have to view the evidence in the light most favorable to Mr. Almonte, and we have to base, and the court has to base the justification instruction based on what he testified about, and assuming that the jury would credit what he said. And I think the question is whether strangulation in and of itself is deadly physical force, and that it creates a significant risk of death or serious physical injury. And it seems analogous to a perhaps a crushing punch, which this court has said does not constitute deadly physical force, but is very likely to also cause unconsciousness or serious physical injury. But it seems like there has to be some more evidence. For example, Your Honor mentioned strangulation can result in death, but the very legislative history that the people cite in their brief indicates that strangulation that goes on for minutes can result in death, while loss of consciousness can occur in seconds. So unquestionably, it's risky behavior, but the question is there a significant risk of serious physical injury?
I think we have that argument. Do you have anything further?
Yes, Judge. Finally, with respect to point 5 on the speedy trial issue, our position is that the people's certificates of compliance were invalid because the people failed to turn over a number of pieces of evidence before they filed those certificates, and the record fails to show that the people exercised due diligence and made reasonable inquiries before filing those certificates. And in particular, there were 3 pieces of evidence, but I'll just focus on 2. The December 29th police report that indicated a possible retraction of the allegations by the complainant, and then body-worn camera footage from October 8th. With respect to the December 29th police report, the only thing that the prosecutor indicated about due diligence in their response paperwork was that they had repeatedly requested all the discoverable materials in this matter. They didn't specify when those requests were made, by whom they were made, to whom they were made, and they did not provide any substantiating documentation such as emails, letters, file notes, or anything along the lines that would have established the precise substance of those requests. The same is true with the body-worn camera footage. There were dates regarding when these things were requested, but there was no substance. And I think it's significant, and the court should consider that these documents were discovered by the police department when Mr. Almonte himself made Freedom of Information Law requests and filed complaints with the police department. And so there's this disconnect between a pro se defendant being able to get the police department to find these things, but a prosecutor making requests did not. And so that suggests that the prosecutor's own inquiries were not reasonable under the circumstances. And as a result, yeah.
Mr. Beck, can you hear me okay?
I can, Judge.
Great. You're aware of the recent case, People v. Bay from the Court of Appeals, right?
Yes.
And so how does this case vis-a-vis the alleged non-compliance with the certificate compliance and the production of automatic discovery, how does this stack up against the factors reflected in Bay? Because one could argue that Bay seems to have adopted a totality of the circumstances, and those are my words, not the court's words, test. Do you think that's accurate, and how does that test apply here?
I think the court has to look at the totality of the circumstances, and the things that I pointed out are the factors that in this case weigh against finding of due diligence, in that the prosecution has to establish and provide some substantiation as to why the diligence that was exercised here was sufficient, and why its inquiries were reasonable. And if the response from the prosecution is, well, we requested these things, this court has no way of determining, well, were these inquiries reasonable? What exactly did the prosecution say to the police department when requesting these things, and what kind of follow-up efforts were made? Or
You've been through that.
So that's part of the totality of the circumstances. And again, there was no explanation why Mr. Almonte was able to get the police department to find these things, and why the prosecution was not. So I think those things weigh significantly in favor under the totality of the circumstances in finding against due diligence and reasonable inquiries. And if that is the court's finding, then our position is that, at least with respect to the second-degree strangulation and third-degree assault counts, more than 6 months passed before there was an announcement of readiness, and at least those 2 counts ought to be dismissed.
Thank you.
Thank you.
Morning, Your Honors. Kaylin Porter on behalf of the people. Certainly, if the court has questions on any of the other points, I'm happy to answer them, but just for the purposes of today, I'll stick to the arguments that were brought up. So first, the unlawful imprisonment. Second, as a lesser included offense, there was no testimony in this case of any restraint other than through the use of the gun. So the fact that unlawful imprisonment doesn't incorporate that, that's just the kidnapping charge. The court still has to act as a gatekeeper on what is a reasonable lesser, if any, to submit to the jury, and the evidence simply didn't make out that it was possible to commit the offense of restraint of the victim without the use of the gun, in as much as all of the testimony pointed to the use of the gun. Moving on then to point 4, the strangulation being deadly physical force. I simply don't see any circumstance that putting your hands around someone's throat and applying pressure is not deadly physical force. That's in the legislative notes from the strangulation charge itself that was already addressed by the 3rd Department in the case cited in our brief. So I would certainly note our strong objection to that just being ordinary physical force. As for the due diligence speedy trial claims, so the defendant's points mostly go to whether or not this evidence was discoverable. Certainly it was discoverable. The people acknowledged that this was a discovery violation, but documented their efforts in requesting this information. And that's really all the people can do in a due diligence analysis, is they can make those inquiries. And certainly they were making those inquiries. They were asking the police department repeatedly, send us any body-worn camera you have, send us any reports you have, and those weren't provided. The Geneva Police Department had assured them, we've given over all the body-worn camera we have, we've given over all the reports we have. The people still continued making those inquiries, so we would state that the people met their due diligence burden in this regard. Unless the court has
Recording in progress.
The court and the people knew Mr. Carmichael's history when they made his original pretrial plea offer. In light of this pretrial plea offer, 16 to life is particularly harsh. Second, Mr. Carmichael did not violate the enhancement warnings given to him by the court. This is not a standard failure to appear case. Mr. Carmichael's counsel sought the adjournment of his sentencing date 2 weeks in advance so that Mr. Carmichael could have medically necessary surgery. Based on the advice he received from his counsel and the actions of pretrial services and probation services who removed his home monitoring devices, it was Mr. Carmichael's understanding that he did not need to appear at the scheduled sentencing date. As he addressed the court, had he known that his failure to appear would be considered to be a breach of the conditions of his originally promised sentence, he would have attempted to appear. Further, Mr. Carmichael was arrested on a bench warrant, and the direct condition given to him by the court was that he was not to be arrested on any criminal charges. And he was arrested on a bench warrant for failure to appear at sentencing. At best, this condition is ambiguous and should be interpreted in Mr. Carmichael's favor. In the alternative, Mr. Carmichael seeks to withdraw his plea. The court imposed an illegal sentence without a fine, and this court now cannot allow an illegal sentence to stand.
So, counsel, with that, what's the remedy?
This court could impose a fine, and Mr. Carmichael...
We can impose a fine here?
Yes, in People v. Bemberley, this court did impose a fine on a AUO charge where the fine was mandatory. And Mr. Carmichael has agreed to waive any complaint about the voluntariness of his plea should this court reduce his sentence to the originally promised one. Mr. Carmichael is also entitled to withdraw his plea here because the court's enhancement warnings were ineffective. At no point did the court tell Mr. Carmichael that he would not be allowed to withdraw his plea should the court adjudicate him a persistent felony offender. And the court also issued the conditions of his enhanced sentence after he had already entered his guilty plea. To briefly conclude, Mr. Carmichael is seeking the benefit of his bargain. He seeks his originally promised sentence plus a fine to remedy the illegal component of his sentence. And I'll rest on my briefing for the remaining points unless the court has any further questions.
Thank you.
Good morning. Martin McCarthy for the People. Yes, the court was aware of the defendant's history. That's part of the reason why when the court was reciting what the maximum sentence was, the court went out of its way to indicate that the defendant was eligible for persistent sentencing. So the defendant was aware that persistent sentencing was something that could happen to him. He then disregarded the enhancement warnings by failing to appear to court and getting arrested on new charges. In fact, when he got arrested on new charges, he knew there had been a bench warrant. He'd done nothing to clear it up. Any explanation as to what the defendant would have done, or his knowledge of the fact that he felt like he didn't have to go to court, that actually wasn't in the record. The defendant didn't offer that as an explanation at the trial level. The court can't consider it here. If there are no other questions.
Thank you.
Thank you.
215, People versus Yura. Good morning, Mr. Keene. Go ahead.
Good morning. May it please the court. Brad Keene for defendant appellant. We assert that the trial court did not understand that it could order a 733 examination at sentencing. This occurred prior to sentencing. Defense counsel indicated some concerns about the appellant's mental health. It included appellant filing a nonsensical pro se motion. The pre-sentence report discussed auditory hallucinations by appellant. The trial court response is, well, it's too little, too late. It was also critical of defense counsel's failure to make a written motion when there's no such requirement in 730-30. The trial court's response was, sir, you need to file a motion or something. He focused on the fact that he had already pleaded guilty. We assert that this misunderstanding of the trial court's abilities under 730-30 should result in this court's remitting for a determination whether 730 is appropriate or just an order for a 730 examination. Unless there are questions on our other points, then we'll rely on our brief.
Thank you. 216 in the matter of Justice H.M. Morning.
Good morning, Your Honors. Gabrielle Gannon on behalf of the Erie County Department of Social Services. I believe that the department believes that it's clear based on the record before you that there is a sound and substantial basis for the trial court to find neglect as the children's physical, mental, or emotional condition was impaired, or was in imminent danger of becoming impaired as a result of the respondent appellant's actions. At minimum, there was an untreated rat infestation in the home.
Well, wait, I'm not so sure that that's true, because she made it very clear that she had tried to get that fixed. She was aware of it. She had been, tried to do it earlier, and the landlord was charging her for doing that, and then she kept bugging the landlord to try to get rid of that, right?
Right, and the landlord had stated that, or the landlord had stated that the apartment needed to be cleaned. She said that she was working on cleaning the apartment so the landlord could come in. So it is her responsibility to clean the apartment.
Your own caseworker, though, said that,
Yeah, listen, please.
yeah, that the apartment met minimal standards.
So my caseworker had that it met minimal standards, and then I believe upon further visits, they agreed that there were safety issues with the rat feces on the baseboards within reach of the children. The one child is crawling. The other child is sleeping on a rat-infested couch cushions. And
We'll look at that very carefully. I don't think they were rat infested. I think that they might have been on top of some rat droppings, but I'm not sure you could say that those cushions, I don't think anyone said the cushions were rat infested, but we'll look at that very carefully.
Thank you. From my reading of the transcript, the respondent appellant had said that she was throwing out the couch because it was rat infested, and then later.
Right, that's why she threw it out.
Well, she didn't. She used the cushions for the older child's bed.
We understand that. Thank you.
Thank you. The older child also was supposed to be receiving crucial services at school. He was enrolled in school and therefore mandated to abide by the attendance policy. He was not in compliance with the attendance policy. The respondent appellant stated that she had means to get the child to school, yet he was not making it school, and therefore it was impairing the services and therapy was supposed to be receiving. And additionally, the respondent did not accept any services from the department. So we would stand and say that her inability to correct or allege these issues put the children in imminent danger of becoming impaired. So again, unless there are any further questions, I will rest on my papers.
Thank you. Go ahead.
Good morning, and may it please the court. Jordan Shank of the Legal Aid Bureau of Buffalo, attorney for the children, justice, and liberty. Your honors, the record supports the family court's finding that appellant placed the children in actual and imminent danger of impairment. The appellant failed to provide the children with adequate shelter and clothing, failed to attend the children's hygiene, and failed to provide the children with access to education and services relating to a disability, which placed that child at risk of future impairment by exacerbating the disability through delayed and inconsistent implementation of services. Therefore,
where are the children now?
The children are now with their non-respondent father. He obtained custody of them in October of 2023.
Anything further?
Was
Yes,
there,
Your Honor.
they were placed with the non-respondent father? They were. Did he petition the court for custody?
He did. So based on the department filing their neglect petition, the children were placed with their non-respondent father when they were removed from the appellant's care. The non-respondent father then filed for custody of the children. He obtained custody of them in October of 2023. They have since been with him and are doing great. They are now in appropriate housing. They have clothing that fits them and is weather appropriate. They receive proper grooming care. Their hygiene is great. And Justice has since been attending school regularly, and she is now receiving her special education services that she so desperately needs.
Thank you very much.
Your Honors.
217, in the matter of Patients E. Thank you. That's 218 and 219. And 217. Sorry, we just have to wait for a moment.
Your Honor, I brought Miss Rijo in, and she doesn't seem to be coming in.
Okay. Shall we call this in a few minutes?
Yes, I can let the attendee know when they're back.
Okay, thank you very much. Do you mind if we're going to just call this in a few minutes, okay? Thank you very much. 222, Echo Ford versus Fayez Shaffy or Shafe, and Justice Del Conte is recused on this matter. Is it Shafe? How do you pronounce that?
Chafee.
Chafee.
Yes, Your Honor.
Thank you.
May it please the Court, Mike Porter on behalf of the appellants. I can focus my comments with the Court's permission on 2 points that I'd like to raise, and subject to the Court's questions on the others, I'll defer to my papers. The first is with regard to the assertion that counsel's comments during summation regarding a mystery witness, a mystery expert who was not called, was grossly improper and must be declared pursuant to this Court's decision in Huff v. Rodriguez to have influenced this jury in an impermissible way. I've been trying cases for a long time, and the notion that an attorney can stand in front of a jury and declare to those jurors that that lawyer consulted with an expert, that that lawyer has decided not to call that expert, and then tell the jury what that expert would have said if he had decided to call that expert. If that isn't impermissible, then I don't know what is. It would give rise to a truly slippery slope of trial conduct whereby, even taken to its natural extension, defense counsel in criminal cases could declare what the accused would have said if he hadn't opted to.
Can I change your focus just for a moment?
Yes, Your Honor.
To perhaps, it's a procedural issue, but about whether or not this appeal should be dismissed. How many appeals, how many notices of appeals do you have out there right now?
There are 2, Your Honor.
And one is here, and the other one is not before this court from the judgment, correct?
Correct, Your Honor. And we addressed that in our reply papers regarding the court's discretion to hear this. I can state for the record that there is no intention to pursue the second notice of appeal, which was filed as a procedural mechanism, given the timing of the first.
Anybody else have any more questions about that? No?
Turning back to the initial point, Your Honors, with regard to that commentary, and it wasn't as if it wasn't teed up in a way that wouldn't influence the jury. Counsel in his opening statement declared that he would call this mystery expert who was not called, and then went on to not only declare to the jury what that expert would have said had counsel opted to call him, but also said that that expert would have agreed with a characterization of the plaintiff's experts that was simply false. A review of the record makes it extremely clear that the question on the medicine was the central issue in the case, and comments by counsel regarding what plaintiff's experts said was false, and then to take it to its natural extension and say, if I had opted to call this expert, that expert would have said X, Y, and Z, which supports our case. It's simply a bell that cannot be unrung. I attempted to deal with it in my own summation, but it's impossible to unring that bell. It's testimony. The second point, Your Honors, is with regard to comments by counsel during summation regarding the manner in which one of plaintiff's experts was compensated. It's well settled throughout the departments that comments regarding hired experts and hired guns is serious error. Those are the court's words, not mine. And it's one thing to comment regarding the amount an expert is paid. To suggest that an expert is not to be believed because of the manner or the amount in which that expert is compensated.
Can I ask, was that?
Yes, sir.
Was there any objection to this whatsoever during the trial?
There had already been objections during counsel's summation. I did not object to that, Your Honor. But as the courts have made clear, as we have briefed, if comments do rise to the level of serious error, the court is absolutely empowered to correct that wrong.
We understand that. Okay.
Yes, Your Honor. And then finally, I said 2, I'll make it 3 with the court's permission, and I'll sit down. With regard to our final briefed point regarding the court's failure to charge on the statutory violation, the New York State Department of Health statutory requirement that medical providers notify the Department of Health regarding communicable diseases. If I understand the respondent's position, it is that there was ample proof before the jury regarding that statute and the fact that it didn't happen. But I would make the one point that it's one thing for that proof to be out there. It's another thing for a court to render, to advise the jury that that statutory violation is some evidence of negligence, and it's that point that we think carries the day with regard to whether or not that should have been charged or not. Thank you. Subject to Your Honor's questions, I'll rely on our briefs.
Thank you.
Thank you, Your Honors.
Good morning. Plaintiff's counsel is asking you to overturn a jury verdict well supported by the proof based upon comments by me that he claims were so egregious that we need to disregard.
Mr. Patton?
Yes, sir.
Good morning.
Good morning.
You cited to AHO in your brief.
To
AHO in your brief.
Yes.
Under that case, that would indicate we don't have jurisdiction to hear this appeal, and we'd have to dismiss it.
On the
A number of
dismissal.
cases that say that.
Yeah, let me address that.
Before you do, my ultimate question is, why didn't you make a motion to dismiss and save everybody the drive up here today so that you could argue these same points upon the appeal from the judgment? That's my ultimate question.
Yeah, I'll provide you the exact truthful answer. It was a scheduling issue. I was in trial, and there were a litany of, actually I was in vacation and then trial, there was a litany of correspondence going back and forth in which I was asking to have a full trial transcript made part of the record. Ultimately, that request was not followed. I think that the record ended up not being stipulated to by us. Next thing we know, there's some extensions, et cetera. So it was simply a matter of me not doing so in time to do so. And so I brought it up in the appeal.
But do you agree that this should be dismissed?
Yeah, I mean, that's the argument. I think that there's 2 things that I can say about that, both I said in my appeal. Number one is that when you have an appeal of an intermediate order, that is sort of overwhelmed or folded into a final judgment when the final judgment is later filed. There is a case in this
We
court.
know this well. just
Okay,
so you
good.
know.
Got it.
I was gonna say that.
Yeah.
But, I mean, you're not the first lawyer to find this out the hard way, making the trek up here to realize, typically we get a motion to dismiss
Yeah.
before it gets to this point, so you save all that time. And again, who knows what we'll do, but, I mean, I'm not so sure it's a matter of discretion. I think it's a matter of jurisdiction.
Okay. Well, and then the only other thing I'll say about that, and you don't need me to tell you the law, as you've made very clear. There is a case one case in this department where the court applied discretion to hear it anyway, although the order was reversed. It had been filed the other way around. And in that case, the court held that it couldn't make a decision in the absence of a full record. So that's the basis there. Would you like me to address the other points? I would be happy to.
That's up to you.
Okay. Let me briefly, just because I'm here with an opportunity to sort of defend my actions, I'll say two things. Number one, I feel rather strongly that my actions were not inappropriate. Number two, they certainly were not so inappropriate that the jury was distracted from the proof or found in favor of the defendant in a way that did not follow the proof. There certainly was a line of valid reasoning that brought the jury to that point, and plaintiff's counsel hasn't even disputed that. What plaintiff's counsel is saying is that my actions were so outrageous that the plaintiff was deprived of a fair trial. I disagree with that. I think with a full record, it's easy to make that
I
determination.
think we understand that argument.
Okay. Anything further that you would like from me, Your Honor?
Thank you.
Okay, thank you.
Wait.
Hold on. Sorry.
Good morning, Your Honors. May it please the Court, Andrew Borelli on behalf of Dr. Perkins Montuali, St. Elizabeth Medical Center and East Utica Medical Group. I won't say anything further about the jurisdiction that the Court's already discussed. I would just briefly say that with respect to my client specifically, if the Court reaches the merits, there are only 5 questions at issue that were offered on cross-examination of 2 witnesses in the middle of this approximately 2-week trial. It's inconceivable how those could possibly have distracted the jury or influence the outcome of the verdict, especially where they were all within the bounds of the trial court's in limine ruling and or sustained based on being outside the scope of direct examination. Unless Your Honor have any other questions, then I will rest on my papers.
Thank you. We're going to go back to case number 2, 17, 18, and 19, please. See, I got all 3 of them.
Maybe that's why it happened.
Hmm?
Maybe that's why it happened that way.
Okay. You need to unmute, but let's go ahead.
Your Honor, can you hear me?
Yes.
Thank you. Good morning, and may it please the Court, Anais Riholalanik on behalf of Erie County Department of Social Services. Your Honors, I want to focus my time on 2 quick points. First, family court saw, heard testimony from several witnesses, assessed their credibility, and weighed the evidence presented, and the court correctly found that the department met its burden of establishing permanent neglect under the 2 prongs of the New York Social Services law, and that determination is entitled to deference. Secondly, Your Honor, given the totality of the circumstances, it was in the best interest of the children to terminate Ms. Evans's parental rights, and a suspended judgment would have been in the contrary. The minimal progress made by Ms. Evans on her menu between fact-finding and disposition does not warrant a suspended judgment. In light of the significant time that surpassed for the children to become more bonded with the foster parents and more estranged with their mother. In fact, Your Honors, as you probably recall, there was an in-camera of the 2 oldest children conducted, which allowed Judge Lovallo to assess firsthand that it was unlikely to rebuild the bonds between the children and Ms. Evans. And that determination is also entitled to deference. Respectfully, these are the reasons that this court should affirm the decision by family court. Your Honors, if there are no further questions, the department rests on its papers. Thank you.
Thank you. You need, there. Thank you.
Good morning, Your Honors, and may it please the court. Roxana Herod of the Legal Aid Bureau of Buffalo on behalf of the children, David, Brooklyn, and Patience. Our position is that the decision of the trial court to terminate the parental rights of the appellant was supported by the evidence put forth at trial. At fact-finding, the department made a showing of diligent efforts, maintaining consistent contact with the appellant, providing referrals to services, and arranging for visitation. The department also showed that permanent neglect finding was appropriate as the appellant had failed to complete her contact employment services and to substantially plan for the future of the children. At this position, the evidence showed that the best interests of the children were served by the termination of appellant's parental rights, based in part on continued concerns during supervised visitation, which appellant never progressed beyond, the lack of positive bond between appellant and the children, and the contrasting close bond between the children and pre-adoptive foster parents. I would
How are
rest
the
on
children doing at this point?
The children are doing fantastic. They are happy. They are in school, receiving necessary services and engaged in a variety of extracurricular activities.
Thank you.
Unless there are any further questions, I would rest on my brief. Thank you.
223, Linda Fry versus Christina Doyle.
Good morning, Your Honors. May it please the court, Adam Delabovi for the appellant Linda Fry. The main contention on this appeal is that the defendant did not meet their initial burden on the issue of serious injury, specifically related to plaintiff's claim for post-traumatic stress disorder as related to this car crash. In moving for summary judgment, the defendant failed to submit any evidence that Ms. Fry had pre-existing PTSD or any of the related symptoms associated with that diagnosis.
Let me stop you there.
Yes, Your Honor.
You say, and none of the related symptoms of PTSD, but she had many mental health issues before the accident. That's pretty well recounted in the record. So
Yes.
you really need to say that the symptoms are not the same, or do you think that they're at least similar?
I think that there's a distinction here where, yes, there is pre-existing depression and anxiety disorder, but there are specific symptoms that there is evidence of after the crash, specifically related to the accident itself, specifically related to being trapped inside of that vehicle. For example, flashbacks to the accident, having nightmares related to the accident, claustrophobia, her inability to wear specific clothing and jewelry, her inability to be in a vehicle without the window open, or her ability to wear a seatbelt while in a vehicle. That's all related to the crash itself.
So it's really not an issue in this appeal as to whether or not PTSD can be a serious injury, because I think the law is it can be, but whether or not there's a question of fact on causation. That's essentially it. Do I have that right?
Yes, Your Honor. And to that, there's no evidence from the moving defendant that it existed prior to. And further on that point, if anything, there's a material issue of fact based on the submission of Ms. Fry's treating provider, Dr. Domenico, who establishes the diagnosis of PTSD and how it relates to that car accident. At minimum, that raises a material issue of fact. And moving on the point of loss in excess of basic economic loss, I refer you to the Woodward decision from the 4th Department. I think that's instructive here, where the moving defendant did not address that issue on her motion, and Supreme Court did not make a determination on that issue. So Ms. Fry's complaint should be reinstated absent a determination on that issue.
Thank you.
Thank you.
May it please the court, Rachel Eminger for the defendant respondent in this case. What this appeal brought by plaintiff, I think, comes down to is really an issue on causation. I believe that the defense adequately met its burden through the submission of extensive medical records,
including her own, correct?
Including her medical records,
yes.
Statements in the medical records that she filled out regarding her pre-existing limitations, complaints, and symptoms, as well as the 3 expert reports that were submitted, I think that the defense more than adequately met its burden on causation with respect to all of the serious injury threshold categories.
Your essential point is the medical records show the symptoms are essentially the same now as they were before the accident, therefore no causation. The question we have to look at in the record is whether we think you carried your burden in that regard.
Correct, exactly, Your Honor. And just for your,
I don't mean to steal your thunder.
no, please do. You're going to say it much better than I ever will, likely. But just to your point on the question earlier, really, I think the case law is clear. It's a documented history of pre-existing conditions, injuries, or symptoms that produce the same or similar types of symptoms that the plaintiff now attributes to the accident. And really, if you do a side-by-side of what she was experiencing prior to the accident and what she alleges from the accident, it's virtually the same. Just overall, I think the court's decision, our moving papers really set that forth with respect to causation. The court below did a thorough analysis of that, went through causation, and specifically stated that plaintiff didn't meet its burden on that issue. That eliminates the serious injury threshold as causally related to the accident, as well as the economic loss claim in excess of basic economic loss. So if there are no further questions, I'll rely on my papers. Thank you.
224, in the matter of Buffalo Teachers Federation.
Good morning, and may it please the court. Robert Quinn on behalf of the Respondent Appellant Board of Education. The trial court impermissibly substituted its judgment in place of the arbitrator in violation of this court's well-documented black letter law prohibiting that type of activity. We would cite Syracuse Firefighters versus City of Syracuse from February of last year to that effect. The arbitrator was doing the job that the parties sought him to do and asked him to do. The issue before him was whether or not the grievance was procedurally arbitrable. The arbitrator applied the express language of the CBA, specifically Article 4A4.
And I assume your argument too is that just because the trial court didn't agree, that's not enough.
It's not a basis to vacate an arbitration award. It's clearly, we submit that the arbitrator got it right. There are these prior awards which we believe were correctly interpreted and correctly applied, but it does not matter for the purposes of this court's decision. You don't need to reach that issue because the trial court impermissibly went beyond what is the extremely limited review that is supposed to be done in an Article 75 proceeding.
Did the court find that there was manifest disregard? Was that part of its decision? Or no?
The court cited the Barone case and the sort of this broad sense of manifest disregard. We go through that standard pretty well in our reply brief.
That's a unique thing to get to.
It's a really unique and remote possibility. That's not what happened here. We have an arbitration decision which I submit is well reasoned, 30 pages, extensively documents, addresses all of the issues. The BTF might disagree with that. That's not a basis to overturn the decision. We have other arguments as to why the trial court went too far, but unless there are any questions, we don't need to address them at this time.
Thank you.
Thank you.
Good morning. Jose Mandrez, of counsel to the Office of Robert T. Riley on behalf of the petitioner respondent Buffalo Teachers Federation. The lower court properly vacated arbitrator Chapman's award. In Barone v. Haskins, this court held that an arbitrator can exceed his or her authority if he or she manifestly disregards the substantive law between the parties.
What is a manifest disregard?
So it is what the Ahern and Lewandowski 1 awards found was that there was a substantive law of laxity, which...
You're saying those two are binding?
I would say that they establish a substantive law. In fact, I would even argue that that substantive law goes further back, which in arbitrator Lewandowski 1's own words, he stated, the parties have a history of repeatedly violating the time limitations time after time. In our view, Arbitrator Chapman was well aware of that substantive law, yet he manifestly disregarded it.
We'll look at that very carefully.
Thank you. If the court doesn't have any more questions for me, I will rely on my brief for the remainder of my points. Thank you.
Thank you very much. 225 Douglas Black versus Black and Calabrese Interior Resource Company.
226, 27, 28. 226, 27, 28.
That's 225, 226, 227, 228, and 229.
Not 229.
Not 229.
We're good.
Go ahead, Mr. Refferman.
Good morning, Your Honors. John Reffermat for Douglas Black. With no opposition, I thought I should ask first if the court has any questions on my brief.
No.
Okay. Hopefully the points in my brief are clear. I think they're obvious, and thank you for your time this morning.
Thank you, Mr. Refferman. Guess what? 2:30. Buffalo Biodiesel versus Bluebridge Financial LLC. And there's only one.
Yes.
One, yes.
One case, right?
So Justice Montour doesn't have to correct me.
Clear the camera.
Good morning, Your Honors.
Good
David
morning.
Tennant on behalf of the appellant, Buffalo Biodiesel. And there are three reasons why the ultimate sanction of dismissal should be reversed. The first is that Bluebridge, the movement, didn't meet its burden to establish that there was more likely than not relevant emails that were destroyed. Second
Well,
is...
emails were clearly purged. You don't dispute that.
That's correct. In a routine hygiene where once
Had to get permission, though, from them to do it.
It's as a routine, when it gets to a certain level, then contact is made saying, you've lost your memory, it's down to X. Do we have your permission to basically take it away so that you now have sufficient memory to run your system?
So they had so many emails on their system that had to be purged.
Well, in terms of spam, that was...
We don't know.
Well, that's coming in from the affidavit of the president of Buffalo Biodiesel.
We don't know about company-wide.
Well, in terms of discovery that wasn't undertaken here, there was no discovery undertaken as to the practices beyond what Mr. Mahamder said in his affidavit. For example, the Mahamder said in his affidavit, for example, the defendant didn't serve interrogatories that would ask for company-wide emails, didn't take the deposition of anyone at the company that would either confirm or deny Mr. Mahamder's statements that he doesn't use email. So I think from the standpoint of the record, there's only one email from Mr. Mahamder that goes to GoDaddy, the host server for the email system, and then one email that goes to a third party that is part of a related transaction dealing with the sale of a truck tractor, but isn't pertinent to the defamation claim. And so what you're looking at here...
Mr. Tennant.
Yeah.
Go ahead. I mean, you know that I was in dissent on Sirac.
Correct.
I think you cited to my opinion. I'm not sure that gets you very far to cite to my dissent, but thank you. In any event, I see where you're coming from here, but here you have a defamation case. It's libel per se for one cause of action and tortious interference with the contract, as I understand it, on the second. And if I'm reading your complaint correctly, liability is based solely on that one email. Do I have that right?
That's correct, Your Honor.
Okay. So in terms of the emails that were purged, destroyed, spoliated, whatever word we want to use, the question really becomes is could those reflect upon damages and causation of damages? And isn't the answer to that here almost certainly yes? Because according to your client, approximately 6 months after that email, CORE reversed course, found lenders at a more advantageous interest rate, but that didn't work out and they had to borrow at a higher interest rate. So the damage, as I understand it to your client, is that differential in the transaction of the yet unknown better deal compared to the emergence or whatever it was they ultimately got. So those emails that may well have been between your client and CORE for those months would be critical to the defense, would they not, with respect to disproving or taking on your claim of damages caused by that email?
I'd answer that in two respects. First is that I think the record requires speculation about additional emails when the record is that Mr. Mahumder, who is the contact, is saying, I have so much spam in my inbox, I don't use it. And if he's not using it, then you'd have to come up with some evidence in the record that suggests that he has a custom habit practice
Counsel,
of using email.
let me interrupt you for a minute. We know from the record that there were subsequent emails from CORE to your client that were not produced. Right, and the thrust of your argument is the court's remedy was too extreme. You don't agree, you don't disagree that the court properly determined there was spoliation here?
Well, the answer is there is insufficient information in the record to take this out of speculation.
But that was the point. Your plaintiff is arguing that we were stuck with bad deals after this. But we don't know what the terms of those deals are, what the offers were, what the proposals were subsequent to the email that you allege is defamatory.
Right. Well, but with Mr. Mahumder saying, I don't conduct my business using email, then the inference, the logical inference, the permissible inference, is that he's using telephone or otherwise communicating in writing, and that's not what the record actually supports in the way of...
Time out, Mr. Dent. The record suggests that nothing was produced in response to the demand of any written communications. You would have had, if you had those, you would have produced them. But according to your client's response to the demand for produce, there was basically nothing, correct?
Correct.
So when you've gone on the path, and forgive me for picking on your one reference to written communications, that can't be so because none was produced. Am I right?
That's correct.
Okay. So we're talking purely about oral communications that your client may want to testify to, that all of which would be hearsay in any event at trial as to what transpired with CORE. So that's not coming in theoretically from the defense side. So you're thinking on the defense side, well, there's got to be some emails with CORE because they were clearly communicating with CORE via email. So all of a sudden they're going to risk showing up at trial and have your client try to testify to those communications and all of a sudden start bringing out emails, oh, we found these after all? I mean, that's a pretty big deal at trial. Wouldn't you be worried about that as a trial lawyer, that your opposition is going to do that to you?
Well, I think you can have guardrails in place that basically put a serious crimp on a party coming in and doing that. And so that you have the ability with an adverse inference instruction as well as kind of the court's inherent jurisdiction to manage the testimony that comes in that basically puts the party that here the movement in a position where it can adequately defend itself. It doesn't have to, the ultimate sanction of dismissal is disproportionate.
Could the court have precluded reference to any emails or communications with CORE? Would that have been within its discretion as a lesser sanction from your perspective?
I think with additional information about Mr. Mahumder's actual practices, taking his deposition, I think this discovery should have been completed before any sanction was imposed. But to the extent that the court has that, I think, within the realm of remedies that it can actually impose, that
would that remedy be any different than ultimately what the court did here? Because if you preclude the references to the communications with CORE, you have no way of proving your damages, correct?
Well, again, I would fall back on the position that there should have been an opportunity to have Mr. Mohamedar and other people at Buffalo Biodiesel basically establish what their practices were with respect to actually using email, and that there isn't, at this point in the procedures of the court had, the ability to say the ultimate sanction of dismissal is the only way to go here. And I think there were intermediate steps, including guardrails that at trial that don't require.
In fairness to your points, Mr., I couldn't find any case of our court, and I'm not sure of any other appellate division where, based on gross negligence, a court struck a pleading. And then I looked at the definition of gross negligence in 2:10A from PJI. Gross negligence means a failure to use even slight care or conduct that is so careless as to show complete disregard for the rights and safety of others. Arguably, that was met here, because when you just don't do anything while you're already in two separate litigations and you do absolutely nothing, that could be met there. But to the point, I think, is that you might say, hey, gross negligence is not enough to strike a pleading. Have you found a case where gross negligence was enough?
No, Your Honor.
And here the motion was under CPLR 3126. The movement didn't cite to the common law doctrine of spoliation. Do I have that right?
Correct.
So under 3126, in the language of that statute, typically there has to be a prior order compelling disclosure or willful destruction, right?
Willful, contumacious, bad faith.
I'm looking at the statute. I think it's willful. In any event, but I know that the case law kind of says they're both the same in a way. But anyways, from my point, I want to let you know I took an extra look at it because of the writing I've done on this, and thank you.
Well, if there are no other questions.
Thank you.
Thank you, Your Honor.
Morning, Your Honors. Daniel LaCour on behalf of the respondent, Bluebridge Financial. I'll just start on gross negligence because I think the record absolutely establishes gross negligence at minimum here. Gross negligence, as Your Honor noted, is the failure to use even slight care. And in this case, I think the spoliation that occurred here exceeds every other ESI case that I've seen. There's the Sage Realty case that perhaps goes further than this case, but in terms of ESI cases, the total deletion of the entirety of the company's emails during pending litigation multiple times.
Let's assume for the sake of argument, just for the moment, and just for my sake only, that we assume arguendo gross negligence. Have you found a case at the appellate division level where the courts have either affirmed or decided to strike a pleading based on gross negligence?
At the appellate court level, I don't believe so. I think it would be.
And Serac went the other way. You know our case in Serac where the court did strike the pleading and we reversed. And Mahiqui's, something like that happened too. I forget, it's not off the top of my head. But so this would be somewhat unusual for us to do, right? But you think that the facts and circumstances here, they're already in litigation. They don't stop it at all. And we can presume relevance from the gross negligence. So this would be, if there is such a case, you would say this is it.
I would, and for two reasons. I think the record would support, if the court had found below, a finding of intentionality here, given all the circumstances. Given the track record of the plaintiff as a litigant, it didn't only have these two cases. It had over 400 other litigations pending in Erie County Supreme at the time.
That's not really before us. It's not in the record.
Okay. It's in my affirmation.
I know there's a reference to it, right.
Yes, Your Honor.
I suppose we could look it up.
The other point is, though, one of the key factors that the court looks in fashioning the remedy is the prejudice on the opposing party. And here, as in the DiDomenico case that we rely on in our brief, what we would have here at trial is the rank swearing contest, where we can't use incisive evidence that may have once existed to actually challenge the plaintiff's assertions. And that's really important here because core funding, our client had a relationship with core funding. Core funding, as we understood it, was a financing broker. But plaintiff is alleging in this case that core funding was not acting as a broker, but was acting to offer it to lend it funds itself. And now all we have to support that is plaintiff's sworn statement that there's been no indication that he's seeking to change his position in that respect. He's offered it multiple affidavits that are in the record. So Our client certainly can testify to its own experience with core funding, but it doesn't have access to core funding. The representative, Mr. Bashkowitz, has gone to the wind.
He could readily be found in California. He signed an affidavit, so I'm not sure that's your greatest argument. People could be tracked down these days very easily. And then that means, you know, that's not a big argument. But the fact of the matter is, as I understand it, you're saying, how can we attack their damages claim without finding what their communications were about with court?
And that's the second point, Your Honor, on that. We don't have any evidence in the record at all as to the terms of whatever loans and discussions were being negotiated allegedly with core funding. All we have are the affidavits of Mr. Majumdar. Our clients have no, insight into what those discussions were. Unless there's any further questions by the court, I'll rest on my brief. Thank you.